You heard the judge, not one, but 2 life sentences in a South Carolina penitentiary for the killing of his wife and son. But it's not over. Why? Murdaugh has a right to appeal. And his lawyer filed that they do intend to appeal. The question is, will he make a case that will make a difference? Now, it is very rare for cases to get overturned on appeal. There was a recent study done by the DOJ that put it at under 20%. And now I'm told by 2 different appellate attorneys that that number sounds high to them. And we don't know what it is in South Carolina. But it's fairly difficult to do. And the idea that the jury decided very quickly, it's not going to be enough on its face. It's going to be what else they can show. So let's have a little trial on what could be an appeal. We have criminal trial attorney Sara Azari and Florida State's attorney Dave Aronberg. It's good to see you, Dave. It's good to see you, Sara. So let's just go point for point quickly here. The big ticket, Sara, I have to believe, because they haven't said what the appeal is yet, but they complained plenty about the financial crimes evidence that got in. So what's the basis for the appeal there?
Well, Chris, look, the financial crimes for 2.5 weeks or 3 weeks, that's all we heard. That's all this jury heard. And then when it came time for closing arguments, Waters, the prosecutor, said, oh, we don't have to prove motive. Motive is not an element of murder, so you don't have to even worry about it. Well, it was the motive that was the guise for bringing in all of that evidence, which essentially was not only character assassination for Murdaugh, but it's what necessitated him taking the stand. So that's why this case is a little bit different than the average case where we go, well, if the defendant takes the stand, then they're essentially opening the door to bad acts and character evidence. He didn't open the door. The door was already open. So that raises a very interesting issue on appeal. I'm not saying it's winnable, but it's certainly a strong issue.
Viable or winnable? Dave, what do you think?
Yeah, good to be with you, Chris. And Sara, she's an awesome criminal defense lawyer, but I disagree with her here because even if there was error here, and I agree that the prosecutors did go close to the line when they elicited testimony that seemed more like character evidence than motive evidence, but ultimately it's harmless error because as we saw from the jurors afterwards, they based their decision on Alex's lack of credibility, his lying about not being at the kennel that day, and his lying when he took the stand about why he lied. That's the reason why he was found guilty. It disgusted the jurors, it disgusted the judge, and even if there was some error, it would be seen by the appellate court as harmless error and the conviction would stand.
All right, let's bounce it the other way, though, Dave, because what she says about the Doyle case, which just for everybody at home means, look, there's a standard that once you invoke your Fifth Amendment rights, you don't have to talk to anybody anymore. You didn't have to talk to anybody to begin with. But for them on the stand in front of the jury, to make it seem like his not going to the authorities to correct what wound up being, the biggest nail in his coffin, which was the inconsistency between his story and what was on his son's Snapchat video, he didn't have to clear it up. Is that something that could be seen as prejudicial enough to have helped shape the verdict and therefore overturn?
No, I don't think so, Chris. I think, if anything, it's harmless error. Look, he took the stand in this case. And when you take the stand in your own defense, that's your own decision, and that wipes away a lot of the mistakes of the trial. Because ultimately, then, it's really about his credibility. That's why the jurors made this decision. Now, is there a Doyle issue here? I mean, perhaps I would disagree as a prosecutor, but again, I think that's small potatoes considering what really went into the jurors' decision. We saw in their interviews afterwards, it wasn't any of that other stuff. It wasn't about financial motive, which, by the way, the defense did open the door to. I'd have to disagree with Sara. It was the fact that he's a liar, a con man, a cheat, and he lied to the jurors' face. They were repulsed by him, and that's why they found him guilty.
Final point to you, Sara.
Yeah, 2 things. One, again, this is with respect to the jurors. The jury, if there's any jury misconduct, there are certainly red flags to investigate. That is not necessarily an appellate issue. It's a motion for a new trial before Judge Newman. If it's denied, then that also can be appealed. But to Dave's point, again, the door was open, unfettered, unlimited amounts of character and propensity evidence came in. So I see this case a little bit differently than just the average case where the defendant testifies and essentially opens the door. to character and motive or propensity.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find NewsNation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of NewsNation's fact-driven coverage.